to this story now that has triggered debate around the country. The High Court in Pretoria has declared lockdown alert levels 3 and 4 regulations invalid and unconstitutional. Reyno Dawid De Beer, Liberty Fighters Network and Hola Renaissance Foundation took government to court. They argued that the regulations infringed on and limited their rights as contained in the Bill of Rights and the Constitution. So let's take this conversation forward. I'm joined by Kathy Powell, an associate professor from the University of Cape Town. Always great talking to you, Kathy Powell. So your take on this judgment, without me putting forward any suggestions or my own thoughts. What do you think of it?
Without influencing me in any way, I think it makes a couple of good points about the law, and then it doesn't apply the law that it set out. So it does make the point that the government is not allowed to just take any measures it likes to achieve the curbing of COVID-19. It's got to limit the rights of South Africans only to the extent justifiable in the Constitution. So it's got to find the best way, the least restrictive way. But most of the judgment was in fact about the test of rationality, which the judge sets out correctly but then doesn't apply. And what he also does is to find a couple of examples of regulations that he says are irrational, though he doesn't explain why, or says they're rational and doesn't explain why. But on the basis of having found a few regulations that he calls irrational, he then throws out all of the level 3 regulations and the level 4 regulations. There are myriads of problems with this. One is the level 3 regulations were not actually before him, because the case actually only started the day the level 3 regulations were being heard, so he was looking at the level 4 ones. Secondly, you cannot declare invalid a regulation you haven't actually analyzed and dealt with. He did exclude from his general declaration of invalidity the challenge against the tobacco ban, because that was being dealt with in a different case. But generally, he threw everything out on the basis of very clumsy, vague reasoning that seemed to express outrage rather than apply the legal criteria.
Sure, that's pretty strong. And I thought I was a critic of the judgment because I was looking at it from a rights limitation perspective to say that, the criteria for determining whether the limitation is justified or not, I was just not satisfied with the extent of the arguments therein. But I was then, convinced by other people that actually the test that was applicable here was the rationality test, because this was administrative action being taken by the Minister of Cooperative Governance and Traditional Affairs in promulgating these regulations. And you are saying even by that standard, it wasn't followed through.
Yes. Look, that is one of the problems with the judgment, is it does seem to slide between the rights analysis and the rationality analysis, but they are two separate issues. The thing with rationality, you're right, it applies to any governmental action, including administrative action. And for the government to show that it's passed the rationality test, it merely has to show that what it did bears some connection, some rational connection with a legitimate government purpose. Now, one of the problems that the court faced in this case was that the government didn't bother to argue its case very well. It simply said, oh, well, we're trying to curb COVID-19, but it didn't explain how the regulations that were being challenged were meant to achieve that. So that was the judge's first problem. But what the judge then did was he explained the rationality test. He said, look, it's not a matter of me deciding there's a better way to do this. All you need for rationality is that the action has some connection to a legitimate government purpose, in this case, curbing COVID-19. But he then proceeds to actually break his own rule. So when he talks about, for example, the banning of nighttime vigils, he says, well, if you want to prevent the spread of COVID-19 by banning nighttime vigils, why don't you rather set extra regulations for nighttime vigils? Now, that's exactly what he said the rationality test is not.
Yeah, in fact, you make my point for me there that initially, in the earlier parts of the judgment, he talks about the rationality test not being about suggesting that there are other measures that could have been taken to achieve this purpose you are seeking to achieve. It's simply about whether what you have done, the regulations you've put in place, are rationally linked to the purpose you are trying to achieve. And I did see that in many of the instances, there were suggestions of you could have done this, you could have done that.
Exactly. And the other thing that concerned me about the judgment was that he often seemed to reject one regulation, not on its own terms, but on the basis of another regulation that allowed for more risk of contagion. So there was this example of this poor hairdresser standing there. She can't dress hair, she can't feed her children, and she sees all these people packed into taxis. Now, I've checked with colleagues because I did wonder, when you're trying to do a rationality test, are you limited to just that one regulation or can you bring two together? And while you can look at rationality as a system, you can't decide that one regulation is irrational because another one seems to be slightly more lenient. And the hassle here, I think, we're moving beyond rationality. We're moving to the point where the executive is trying to factor in not just curbing COVID-19, but also keeping the economy going, supporting mental health, and so on. Admittedly, in this case, the government didn't bother to mention those legitimate government objectives, but they are there. So all of these regulations might be slightly different because they're trying to find the fine line between these various government objectives.
Yeah.
Now, fine, the government didn't mention those objectives, so all that the judge had to deal with was curbing COVID-19. But nonetheless, I got increasingly uneasy with the way he rejected one regulation on the basis that there was another one. I think perhaps the best example is when he gets upset was what it sounded like from the text, with the ban on informal trading, while there is a permission to attend funerals as long as no more than 50 people go to it.
All right, Professor Kathy Powell, thank you so much. Always appreciate your insights. Just one more of those takes on that particular judgment of the High Court in Pretoria. It will be interesting to see whether or not government takes it forward by way of an appeal, but certainly a few of the legal commentators and scholars not really impressed with the way that the judgment has been written.